and welcome to the 40th annual Fornoff Competition Finals. This is always a highlight of the school year, and today's event is even more special by the fact that it's the 40th anniversary. The competition, as you can see from your program, is named for a former dean of the College of Law, Charles W. Fornoff, who worked as a faculty member and dean for 31 years. It's in his tradition of excellence that we hold this competition. The purpose, of course, is to impart oral advocacy skills and proficiency as a lawyer. The Fornoff Competition is the cornerstone, along with legal research and writing, of our moot court program, which is fielding several teams this year. As many of you know, 2/3 of the current second-year class participated in Fornoff, and starting last spring. And the finalists here today are the survivors of the grueling double elimination tournament that went on for several weeks. I want to thank and congratulate all the participants in Fornoff, and the members of the moot court board and the faculty who judged the rounds. The chair of the moot court board, Johnny Short, the vice chair, Kayla Buck, the Fornoff coordinators, Josh Driscoll and Chris Lawrence, who I know have been working very hard. Over the past 2 weeks, the 4 finalists have been practicing diligently to hone their arguments, and I especially want to thank Associate Dean Lee Pizzamenti, who advised the Fornoff competition and who worked with the finalists during the past 2 weeks. We have a terrific panel today. Their biographies are in your program. Judge Jeffrey Sutton of the Sixth Circuit Court of Appeals, Judge Benita Pearson of the United States District Court for the Northern District of Ohio, and Peter Casey, who was the student who 40 years ago asked then Professor James Carr, now Senior U.S. District Judge Carr, if he would help organize an internal moot court competition. And that's what started the competition that has been going on for 40 years that we celebrate today. We are now ready to start. And to open the court session, I will turn the microphone over to the bailiff, Chris Lawrence.
All rise. All persons having business before this, the Honorable Supreme Court of the United States, are admonished to draw near and give their attention, for the court is now sitting. The Honorable Jeffrey S. Sutton, United States Court of Appeals for the Sixth Circuit, presiding Chief Justice today. The Honorable Benita Y. Pearson of the United States District Court for the Northern District of Ohio, and the Honorable Peter R. Casey III, member at Eastman and Smith. God save the United States and this honorable court.
Be seated. Welcome to the United States Supreme Court, at least for a few minutes. Is Petitioner's Counsel ready?
Yes, Your Honor.
Respondent's Counsel ready?
Yes, Your Honor.
Okay, we'll hear from the petitioners.
Mr. Chief Justice, may it please the court, my name is Brad Levine, and I, along with my co-counsel, Charles Hatley, represent the petitioners of the Hope political party. May I reserve 2 minutes of our time for rebuttal?
Yes.
There are 2 issues before this court. My co-counsel will address whether a conspiracy to marginalize citizens for their political affiliation violates 42 U.S.C. Section 1985-3. I will address whether a content-based restriction on the expressive conduct of a political party requires the O'Brien standard of intermediate scrutiny under the First Amendment. The position of the petitioners is that the lower court erred in granting the respondent's 12b6 motion, and we pray for this court to remand this case with instructions to apply the O'Brien standard of intermediate scrutiny for 3 significant reasons. First, it does not further an important governmental interest for respondents to entrench the dominance of a political majority in defiance of the will of the people. Second, respondents' scheme to control the outcome of the ballot initiative is a content-based restriction meant to suppress the petitioner's freedom of expression. And finally, Your Honors, even if other forms of expression remain open to petitioners, the law does not require that they substitute their First Amendment protection for more burdensome alternatives.
So in the abstract, can you have a supermajority requirement when it comes to legislative initiatives? I mean, is that something a state can do in the abstract? Well, forget what happened here, but is that okay, or does that have speech suppression problems?
Justice Sutton, a supermajority in and of itself is in no means a problem, and that is not the position of the petitioners. Certainly, as respondents will note, you see a supermajority in different facets of the government. However, where it becomes a problem is where you find that it has suspicious timing, as seen based on the facts in the claim. What we have are a group of citizens who formed a political party with the intent of getting on the ballot initiative and reforming electoral college votes for the presidential election. In response to that, the respondents, on behalf of the Republican Party, amended the Constitution to include these content-based supermajority requirements and masqueraded the amendment as content neutral when it is in fact content-based.
It sounds to me like political suppression, not speech suppression, and there seems to be a difference.
Your Honor, this court in Meyer v. Grant broadly acknowledged that when citizens wish to engage in the political process, it implicates the First Amendment. And certainly there are both personal and structural restrictions that can be at play. When the government passes an amendment such as the Scranton Amendment, it would be a structural limitation. However, it can still have a chilling effect on the speech and conduct of the citizens. In this case, that chilling effect would be their desire to have expressed their views through voting on electoral college reform. And of course, as my co-counsel will address more fully, not only was the Scranton Amendment passed in this fashion, but the respondents, the governor, the party of the Republicrats, and the police chief all got together and conspired on how they could marginalize these particular citizens. That is both subject matter-based discrimination as well as viewpoint-based discrimination, Your Honors.
What law that has ever been passed does not contain viewpoint discrimination? Isn't that the whole point of a law? It is one view out of two, or three or four, and that view becomes the law. Isn't it really strange to start saying, oh, shoot, we better apply strict scrutiny every time a debate is resolved through legislation?
Your Honor, the position of the petitioners is that, of course, when a law is passed, it's going to implicate to some extent views. However, it is when you have the particular facts in the context of a case such as this one where it becomes a problem.
That really is the timing point, right?
Correct, Your Honor.
Just to clarify the issue regarding timing, is it your position that had the initiative or the legislation been changed closer to January when the votes were collected, you wouldn't be here today, but rather the problem is it was closer to the November voting date? Is it truly just a timing issue?
It's not just a timing issue, Your Honor. It's the overall chilling effect on the quantum of speech. Most of the cases that the respondents are likely to cite from lower courts, for example, Initiative and Referendum v. Walker by the 10th Circuit, they contained supermajorities that were already in place. That is a fundamental difference, Your Honors, in this present case. And the concern of the petitioners is not just the impact on the individual members of HOPE, but furthermore, on the effect it will have to spur public debate on this issue for future reformists who might wish to change the ballot. And furthermore, Your Honor, the important policy issue here that petitioners wish to bring to the attention of this court is not just the chilling effect, but our system of democracy is based on checks and balances, on the separation of powers. Here, we have a dominant state where the Republicans are in both houses of Congress and the governorship, to the extent where the governor is one of the named respondents. And there is no other source for the petitioners to turn to other than this court and the lower courts in order.
And other than the next election.
Your Honor, certainly in the next election, the voters could come out and vote on the issue. However, voters are discouraged from doing that.
So let's say that's how it does play out, that this lawsuit had never been filed. They do the 75% requirement. It has its effect. They can't make the change. And the tables do turn. The opposing party now is in control. And this time around, the opposing party says, wow, 75% supermajority, that is just too high. We're going to reduce it to 60% or 51%, and we're going to make it super minority, 45%. And they all have political reasons for doing it, to further their political ambition. I take it the same constitutional First Amendment claim could be filed there, right?
Your Honor, only if it was done with suspicious timing, where it was paraded as content neutral as the Scranton Amendment, when in fact the purpose was discriminatory. If those...
Oh, how about this timing thing? I mean, is it not a little suspicious that the framers of the U.S. Constitution, in putting together their handiwork, said it's going to require a 3/4 majority of the states to overturn our excellent, excellent good work? That strikes me as the worst timing possible. The very people that created the Constitution made it almost impossible for anyone to change it. But it never occurred to me that you could undermine that with a free speech claim.
Your Honor, if you're talking about amendments to the Constitutions being passed through both houses of Congress, that's a checks and balances on the government itself. Here, this restriction, Your Honor, is directed at the people. That's why the people need to be able to turn to this court and the lower courts to be able to act as a system of checks and balances. There is no other source for them. And Your Honors, conduct is no more expressive in our democratic society when people wish to go to vote on an issue of importance.
From a practical standpoint, is there any impact from the fact that this 3/4 super majority only applies to this particular initiative? Does that play into this at all? Should we consider that in any fashion?
Yes, Your Honor. On page 20 of the complaint, this court will note that the plaintiffs allege that it was specifically focused on the Electoral College reform. In that sense, it was subject matter based, but also directed to the viewpoint of the petitioners, and that should be considered by this court.
Does that fit in anywhere in the O'Brien standard?
Yes, Your Honor, because if we look at the elements of O'Brien, may I have an opportunity to respond and conclude, Your Honor?
Yes.
Yes, go ahead.
If we look at the elements of O'Brien, the second and third elements in particular, it has to further an important governmental interest, and it can't be related to the suppression of free expression. This was passed with the intent to suppress their free expression, and for that reason it would fail the O'Brien standard, and this court, therefore, based on these facts, should find that the O'Brien standard applies, and we pray that it remands this case for decisions on those merits.
Thank you.
Thank you.
Mr. Chief Justice, and may it please the court, my name is Charles Hatley, and I come before you today to address the Hope Political Party's second cause of action, a violation to 42 U.S.C. 1985-3, which occurred when respondents acted upon their conspiracy to marginalize the Hope Political Party, resulting in a violation to the First Amendment of our Constitution. There are two issues regarding 1985-3 before this court today. The first is whether the Hope Political Party is an identifiable class, and the second is whether respondents' tortious conduct rises to the level of invidious discrimination. We come before this court today to respectfully pray to reverse the decisions of the lower court. The violation of 1985-3 occurred when respondents conspired to marginalize the Hope Political Party, and respondents conspired to marginalize Mr. Jimpert by having him arrested. The very next day, respondents arrested Mr. Jimpert, Mr. Howard, and Ms. Pamsley as the three silently stood outside the Capitol building of the state of Scranton, holding signs in support of the Hope political party, stripping them of their right to petition and lobby in favor of their ballot initiative. These arrests were so offensive that a district court judge in the state of Scranton immediately dismissed all charges because there were no grounds
Tell
for
me
these
this,
arrests.
could they not have brought a false arrest claim under state law? Or for that matter, a false arrest claim in violation of the Fourth Amendment?
Your Honor, in this case, it goes farther than a false arrest claim.
But they could have, right? I mean, the police are not allowed to just pick up anybody off the street there's no probable cause they've done anything wrong and just arrest them. And if they do that, they're subjected to false arrest claims under state law and Fourth Amendment 1983 claims, right?
Yes, Your Honor. But this case also includes conspiracies to arrest, acting upon that conspiracy, and an injury resulting from that conspiracy. As this court set out in Brotherhood of Carpenters v. Scott, there was a 4-step test to decide whether a conspiracy exists. And following the rules of 12b-6, there is no question that a conspiracy exists before this court today. In Scott, this court stated that for a conspiracy that does not involve race-based animus to be actionable under 1985-3, there must be a violation of a federally protected right by a state actor, and there must be class-based invidious discrimination. In the
And
case,
isn't that your weakness, the class-based invidious discrimination?
Your Honor, the Hope political party is an identifiable class when following the standards set out by this court in Bravey Women's Health Clinic of Alexandria. This court stated that an identifiable class under 1985-3 is a group of individuals with an identifiable existence beyond that of being victims of defendants' tortious conduct. This court gave the example that Republicans could be an identifiable class if there was animus towards Republicans because they are Republicans, showing that this court does not foreclose the idea that political-based animus can be actionable under 1985-3.
But this political-based animus that exists before us, is that the same as what the legislators had in mind when Section 1985 was put into place or eventually codified? I mean, you have some idea. I mean, it was called originally the Ku Klux Klan Act, right?
Yes, Your Honor.
And the invidious discrimination it was designed to prevent seems to be a marked difference from what's before us today, rather that of whether or not political parties should have an advantage until the next election.
Yes, Your Honor. 1985-3 was designed to protect against two types of conspiracies. A conspiracy to deprive an individual or class of individuals from the equal protection of the laws, and it was meant to protect against conspiracies to deprive an individual or group of individuals from their right to support a qualified political candidate. In this case, the language of 1985 is clear. The framers' intent is clear that they meant to include political-based animus within
Isn't their intent best expressed in the language of 1985, conspiring to deprive any person or class of persons of, quote, the equal protection of the laws? I mean, you wouldn't think that would apply to, quote, political discrimination. I mean, it's not a discrete and insular class.
Your Honor, 1985-3 also states to not deprive an individual from the right to support a qualified political candidate. In this case,
Well, tell them, how would you act to this one? Because this seems to me to happen all the time. You have a redistricting situation. You have a state, say Ohio, with 2 fewer seats for the next decade. And so they have to redesign the electoral districts, and it means some people are going to be left out. Could the party in control conspire to remove one person from the opposite party from a district? I mean, is that a cognizable 1985 claim?
Your Honor, 1985-3, the test was set up in Brotherhood of Carpenters v. Scott. In that test, there must be a violation of a federally protected right by a state actor, and there must be class-based.
But I mean, what's the answer to the hypothetical? We know they're sitting in a conference room, and the people of one party are saying, we don't want that person to have a district. So what we're going to do is we're going to draw the line so he or she can't win next time. Is that a 1985 claim? So opposite political party, it's a conspiracy, there are a bunch of them, and they're on the opposite of the opposite political stripe.
Yes, Your Honor. This court has recognized political gerrymandering under the Equal Protection Clause. And this court in Caminetti v. United States stated that when a statute...
Political gerrymandering redundant? What gerrymandering is not political?
The gerrymandering...
And that seems like it's the problem, right? It's all political.
Your Honor, there are political-based conspiracies. And in this case, this particular political conspiracy, the victims discovered animus there's animus directed towards victims because they are members of the Hope political party. And this animus is because of respondents' wish to marginalize the Hope political party. Respondents violated the federally protected right of the First Amendment free political expression. This completes the test set forth in Scott, only leaving open the question of whether the discrimination was invidious. This court defined invidious in Bray as any action exciting odium or ill will, or that is obviously discriminatory. In this case, respondents arrested petitioners as they silently stood outside the courthouse of the state of Scranton, holding signs in support of the Hope political party. A district court judge immediately dismissed all these charges. These arrests by respondents excite odium, and these arrests excite ill will. These arrests were obviously discriminatory towards the Hope political party. And in Farber v. Patterson, the Third Circuit stated, whether tortious conduct rises to the level of invidious is a question of intense query, leaving open a question of fact before this court today. In conclusion, the Hope political party is an identifiable class. There has been a violation of the federal...
What's your best case in terms not of language in the case, but best case with facts similar to this, where you really could say what's going on is one political body discriminating against the members of another political body, and the court then saying, hey, that's a cognizable 1985 claim?
In Conklin v. Loving, the Sixth Circuit stated that political-based animus is actionable. In that case, there was a member of a political party who was...
That case is deserving of much respect here?
Yes, Your Honor, I do.
Okay, that's a good answer.
That case followed the holding in Scott closely, and the court wrote that because this honorable court in Scott did not foreclose the possibility of political-based animus being actionable under 1985-3, that political-based animus was actionable under 1985-3.
And remind me, the facts of that case involved one political party versus another?
The facts of that case was there was a supporter of a political candidate who worked in a government office, and when the new political candidate won, came into office and fired the supporter of his opposition. The Sixth Circuit held that that was political-based animus and that that was actionable under 1985 Section 3. In conclusion, this case involves a violation of a federally protected right by a state actor. This involves class-based invidious discrimination, and this is actionable under 1985-3. The law requiring a supermajority vote creates a disparate impact, and it was created with discriminatory intent and must be viewed using an intermediate level of scrutiny. Petitioners have stated claims upon which relief can be granted, and for these reasons, we once again respectfully ask this court to overturn the rulings of the lower court and remand this for further proceedings. Thank you very much.
Thank you. All right, I think we'll hear from the respondents.
Mr. Chief Justice, and may it please the court, my name is Catherine Green, and I, along with my co-counsel Soren Dorius, represent the respondents, Mr. Michael, Mr. Shrewd, and Mr. Joss. The respondents respectfully request that this court affirm the circuit court's decisions dismissing the actions, because petitioners have failed to state a legally cognizable claim upon which relief can be granted. There are two distinct issues before the court today. My co-counsel, Mr. Dorius, will address why the scope of 42 U.S.C. Section 1985-3 does not allow for claims of conspiracies based on political affiliation. I will be addressing why an amendment to the Scranton Constitution that is both content neutral and that does not implicate the First Amendment is rationally related to a legitimate government interest. Petitioner's claim does not implicate the First Amendment for two reasons. First, the First Amendment does not extend to protect the results of free speech, only the speech itself, which is not at issue here. Second, the supermajority amendment is not discriminatory and does not burden free speech. Therefore, because the First Amendment is not implicated, the correct test to apply here is rational basis review.
I'm confused by what you mean the results of free speech are not protected. Isn't the fact that the supermajority is being required imposing this chilling effect that you heard opponents speak about, such that people will not go to the polls, and even if they do, the likelihood of achieving 75% or greater in favor of the initiative is less. So it's the action that could lead to the passage of the initiative, not the result.
Your Honor, there is no chilling effect on speech here. Petitioners are still completely free.
Let's get to that second, but speak to me so that I understand what you mean by the result, not the expression itself, if you can.
Yes, Your Honor.
Thank you.
The supermajority amendment is simply a procedural mechanism, not a personal limitation on speech, which is generally what's prohibited and subject to strict scrutiny. Procedural mechanisms have almost universally been held to only require rational basis review. Therefore, I'm sorry, I forgot the second part of your question that I started responding to.
You were clarifying for me your opening statement that it's the result that is at issue here, and that is not protected. And I was challenging because I believe it's the action leading to a hopeful result that is being challenged. Does that help?
Yes, thank you very much. There is no chilling effect here because petitioners are still completely free to engage in any type of speech that they desire about the ballot initiative process and the elections in general, and the apportionment of electoral college votes. The circuit courts, when addressing this question, have uniformly held that as long as you're able to speak on the topic, that is not a speech restriction.
Let's assume, just for a moment, that this is expressive conduct. Okay, you understand what that is?
Yes, Your Honor.
What is the important governmental interest in making a supermajority for this initiative and only this initiative?
Your Honor, there are several important governmental interests that are advanced here.
That's what I want to know.
The first is that 48 other states and Washington, D.C. all apportion their electoral college votes similarly to the state of
But what
Scranton.
is the important governmental interest in this case, in this state, in this particular instance?
Yes, Your Honor.
Not what has happened in other places, but what is it here?
The reason I address that is because there's so many other states that do this, it raises a presumption of validity and
I understand
indicates...
that, but what is there, let's put aside a presumption of validity. What is the important governmental interest in this case?
The important governmental interest is to help preserve an important and valuable democratic inheritance. The fact that there are that many states...
What does that mean?
You either think all or nothing electoral college rules are good or they're not good. I think that's, are they good or not?
Your Honor, the fact that there's 48 other states that do indicate that they apportion their electoral college votes similarly indicates, and the respondents also agree with that, that is a good way to apportion the electoral college votes. Ballot initiatives are an extremely important topic, especially this one because it has the potential to affect national presidential elections. Having 51% of the voting public make big constitutional decisions is not advisable or desirable, especially when the political process can all of a sudden be subject to the whims of a transitory majority.
So wouldn't you say voting, you know, the right to vote and speak about voting, those seem like First Amendment type issues, right? I mean, a vote is an expression of your views.
Your Honor, petitioners could not cite any case law, and in fact, there is no case law that says that voting is expressive conduct.
Well, that the area of law is underdeveloped, which is what no case law tends to mean, doesn't mean that we shouldn't further develop it, correct?
That's correct, Your Honor. However, there are numerous case laws, that do address voting, procedural mechanisms, the elections process, ballot initiatives, all things that have to do with that. So it seems that the area is not necessarily underdeveloped. However, this specific question has not been presented, but it does flow very naturally along with all of the case precedent, Supreme Court precedent, and Circuit Court precedent, that this is simply a procedural mechanism and not a limitation on speech.
I'm troubled by your comment that and perhaps I misunderstood it, but that a 51% or majority vote of the electorate is a problem.
No, Your Honor, I'm sorry if that's what I implied. That was not what I meant. 51% of the majority making constitutional decisions is not advisable or desirable. The framers obviously also had this intent in, as Justice Sutton pointed out in questioning earlier.
So the important governmental interest is that other states have chosen to do it with supermajority? Are there states that have chosen to do it with simple majority?
There are
in the legislature?
There are 2 states that apportion their votes.
So am I correct that your position is that that is the important governmental interest, that other states have done it likewise.
No, Your Honor, respectfully, that is simply an illustration of why we believe that this is an important governmental interest. The important governmental interest here is to just ensure that any changes to this important democratic institution is a deliberate and rational change made by the public.
I mean, I think supermajority requirements sound like a good idea and certainly a constitutional one, particularly given their appearance in the U.S. Constitution and elsewhere, but it's so strange here where you have it just as to one topic. That's what seems to delegitimize it. And then you add to it the timing, and you start to have some sympathy for your friends on the other side's view.
Your Honor, with respect to the timing, it was considered for almost a full month before the legislature passed it. There is no evidence in the record that indicates that
They were slow in coming up with a politically ingenious idea. I mean, I don't know what that means, 30 days?
Your Honor, there's no evidence in the record that indicates that there was any sort of discrimination, content-based. You can look at the language of the supermajority amendment. There's no indication in the record or in the language of the amendment that there was any sort of content-based or viewpoint-based discrimination going on by the Scranton legislature.
Why then is this the only issue for which the legislature has this particular legislature has chosen to make it a supermajority? Any other initiative to change any other part of the Constitution would be by a majority vote, correct?
That's correct, Your Honor.
Why then, in this case, is it a supermajority?
This has always been kind of out there, but not necessarily brought to the legislature's attention just because nobody thought that this would be something that would need to be changed or desired to be changed.
Is that in the record anywhere?
No, Your Honor. And so it was simply brought to their attention and they responded accordingly, again, for that important governmental interest that we're advancing, just to make sure that any changes in the important democratic institution that is the winner-take-all electoral college scheme is made by a deliberate choice. 3/4 supermajority requirements are common procedural mechanisms at the state and federal level. For example, Arkansas, Michigan, and Oklahoma all require them for tax increases, and they're used in many other states for other reasons such as land use and appropriations bills and the like. The national constitution, again, also requires 3/4 of states to ratify the Constitution.
Do you know of a time in history when anyone's imposed a 3/4 majority requirement after taking a poll that shows that 62% want something?
Yes, Your Honor. In Initiative and Referendum Institute versus Walker, a recent extremely factually similar 10th Circuit case, the same thing happened. There was extensive campaigning, ballot signature collections, and the like, and then the legislature, and this is even with specific discriminatory comments to the media, indicated that they were passing this to make sure that the out-of-state interests that were proposing the ballot initiative elections were not successful.
I don't remember that. That too was a case where you had, here it's 62%. There it was more than 50% of the people wanted the change, and then the supermajority requirement was imposed on top of it and happened to be just above the public opinion on the particular issue.
Your Honor, I see that I'm out of time. May I please have a moment to respond and conclude?
Sure.
Your Honor, as far as I'm aware of the facts, that was the facts of the issue. The people desired the change. Like I said, there was extensive campaigning and ballot signature collections. It was a lengthy campaign. It was 7 years, and up until that point, nothing had happened until this legislature passed the issue when it was raised. So for all the foregoing reasons, respondents respectfully request that this court affirm the lower court's decisions. Thank you.
Hey, thank you. We'll hear from your co-counsel.
Good afternoon. Mr. Chief Justice, and may it please the court. My name is Soren Dorius, and I am here today representing the respondents in this case, Governor Scott Michael, Dwight Schrute, and Porter Joss. I will be addressing the second petitioner claim, whether allegations of political conspiracies fall under the scope of 42 U.S.C. Section 1985. The respondents respectfully request that this court uphold the sound decisions of the District Court of Scranton and the 17th Circuit Court of Appeals, which found in favor of the respondents. I will address two specific reasons why this court should reject the petitioner's claims for a broader interpretation of Section 1985. First, that the purpose of Section 1985 was to combat racism, and second, that the policy implications of including such a broad interpretation would have a detrimental impact on this government structure and political system.
Is combating racism part of the language in Section 1985?
Your Honor, the language is actually quite broad, and this court in Carpenters and Joyner v. Scott interpreted the meaning and purpose of Section 1985, in fact, to be the predominant purpose to combat racism.
But even predominant purpose, and I won't disagree that certainly was a predominant purpose, but that's not its only purpose. You're not maintaining, are you, that if it's not a matter regarding race, 1985 is not actionable?
Your Honor, this court has never held anything outside of a racial animus to be included under Section 1985. While it's true that there are numerous courts in the appellate level that have broadened the scope of Section 1985, the majority of those, in fact, all but one circuit court have found that those are immutable characteristic groups and classifications. Your Honor, the petitioners have brought...
Do I understand that you are asking us to consider 1985 to only comprehend race issues?
Your Honor, the respondents are requesting that this court uphold the decisions that they've had in the past.
That could be a very simple yes or no answer.
In response, quite simply, yes. While the respondents would be open to a broader interpretation if we were to include immutable characteristic classification, as other appellate courts have done, the respondents request
Do you want to tell us what an immutable classification is?
Your Honor, under other equal protection claims, classes such as gender, race, as we've been mentioning here today, alienage, and non-marital.
Basically anything that gets intermediate or strict scrutiny? Is that a way to put it?
Your Honor, perhaps that might be one way of putting it. The best alternative is to look to the way that this court has reviewed cases under Section 1985, and this court has only found that classes of racial animus have a claim under Section 1985. In fact, this court, when reviewing the legislature and the legislature's intent when they enacted this Civil Rights Act in 1871 that included Section 1985, they found that the political animus aspect of it was not convincing.
Well, it's true, you said that about our decision in Scott, but you're talking about what that Congress found or that Congress thought. We have their words, equal protection of laws, that could cover an awful lot of things if you look at that. And then we have this legislative history, which does talk about race, does talk about the Klan, but then conspicuously talks about the Republican Party, which was affiliated with folks trying to prevent this type of racism. So, I don't know. Why isn't that pretty legitimate? And why isn't that a pretty good indicator that equal protection laws can extend to discrimination against the political class?
Your Honor, as this court did note that there were other classes that were protected during the enactment of this 1985. It was the Republicans as well as the Northerners, but this court noted the ties that those parties had to a racial animus. In fact, they said that regarding the predominant purpose being a political animus, that it was to protect as the court noted, to protect African Americans as well as their supporters. And so the Republicans and the Northerners at that time were being persecuted because of their support for the racist attacks by the KKK movement. And Your Honor, as Justice Sutton noted, that other cases, if we were to interpret the broader interpretation of Section 1985 that the petitioners are requesting, other cases this court might hear would have claims such as a gerrymandering situation where overbroad political animus would have a deep implication on this court. There would be far more cases outside the original scope and intent of Section 1985 that was intended by its framers and the intent and interpretation of this court in Scott and Griffin. Your Honors.
Well, the way to distinguish that is, this is really discriminating against the people, because the people have a majority will to do something, and the entrenched political majority is not letting them do that. And that's different from gerrymandering, which really is one politician against another politician.
Your Honor, certainly there are differences between the facts of this case and, say, a gerrymandering situation. However, if this court were to include a broad interpretation of political animus as a whole, a political affiliation, having claims under Section 1985, certainly there would give rise to other situations such as the gerrymandering or any other dispute. In fact, this court specifically noted in Scott 2 distinct warnings of likely situations that would arise from having a political animus. One of those specifically that they said was that it would make the courts and require the courts to go far toward making political and campaign tactic rulings for both state and federal elections. They also note a specific scenario where they say, quote, when a political party has interfered with the freedom of speech of another political party by encouraging, say, the heckling of its rival speakers and the disruption of its rival meetings, that they would arguably have a claim under Section 1985 because of including a political animus, something that the framers, once again, of this legislation certainly did not intend to have a chilling effect on the political sphere as a whole, but in fact it was to protect and discourage the racism that was rampant during that time period. Your Honor.
Which was rampant, but being opposed primarily by the Republican Party.
Your Honor, certainly there were ties between the political parties and the acts that were taken, the violent acts that were taking place, but the purpose of Section 1985 was to eliminate the racism that was occurring and not to block the disputes that arise normally.
What if the prompting of the racism really comes from a political source? I mean, I think, what is it called, the Know Nothing Party? I mean, I think they were some of the worst. And so you have the Know Nothing Party out there passing discriminatory laws, promoting private and public discrimination. You really couldn't bring it. I mean, I get the point that maybe it doesn't invariably apply to political party discrimination, but can it not apply in some settings? And you could argue that's all they're really saying. This is one of those egregious settings.
Your Honor, the petitioners offer such a broad interpretation of Section 1985 that virtually any person would have a claim under 1985.
I think they'll take as narrow one as will work, would be my guess.
And the counterpoint to that is your restrictive interpretation has its own adverse consequences. So perhaps the answer is someplace in the middle.
Your Honor, well, as Justice Sutton noted, there are other remedies for tortious actions that took place, especially on the state level. A false imprisonment charge might be more appropriate, but to apply all conspiracies for any kind of group certainly wasn't the intent and purpose of Section 1985.
But what if this had been the Klan? So the Klan is the party that is behind all of this. So the Klan's the one that doesn't like this upcoming change. The Klan's the one that imposes the 75%. Okay, now what?
Your Honor, the Klan itself would have certain rights to do so. If the motivation behind those actions were racial, then certainly there would be a discriminatory charge and claim under Section 1985. But the Klan as itself as a group certainly is entitled to make those changes and to do so without.
It doesn't seem like a very big step to think that the Klan as a political party would have those racial motivations.
Your Honor,
that's what they're known for.
This court has given rights to groups to have the opinions that they want to, so the Klan itself can still exist today and be afforded certain protections. However, one thing that they can't do is racially discriminate against another individual, and that's why Section 1985 does exist, is to protect against those circumstances and situations where that would occur. Another point that the respondents would like to make, Your Honor, is that the definition of political party itself is very gray and blurry and would be better suited for the United States Congress to determine what, in fact, would fall under a political party and affiliation.
But there's no question in this case that HOPE is at least a putative, a wannabe, a baby political party, correct?
Your Honor, certainly the HOPE is a single issue party, but if this court were to in fact include a political animus under Section 1985, then the question arises as to who and what would be classified as a political affiliate. Today, in recent times, we've seen vast movements of, say, the Tea Party movement, or even more recently, the Occupy Wall Street movement.
Under the Brotherhood of Carpenters rationale, doesn't the fact that these individuals were held political office make a difference?
Your Honor, in respect to that, the individuals certainly were state actors that were involved. However, once again, because there's no racial animus or otherwise immutable characteristic that's being targeted here, there's no reason why a Section 1985 claim would be applied to the facts of this case.
So your rationale is simply that it doesn't apply because there is no coverage for political parties or political action groups. Would that be fair to say?
Your Honor, I see my time has expired. May I briefly address your question and
Yes.
conclude? Quite simply, this court has never found anything outside of a political animus, and the respondents request that this court continue to uphold that decision. If they were to expand beyond, say, a racial animus, then it should include classes with immutable characteristics, as have been mentioned, certainly not political affiliation. And for the foregoing reasons, the respondents respectfully request that this court uphold the sound decisions of the District Court of Scranton and the 17th Circuit Court of Appeals, which found in favor of the respondents. Thank you.
Thank you. Petitioners, I think you may have reserved 2 minutes. Rebuttal?
Mr. Chief Justice, and may it please the court, there are 2 issues upon rebuttal. First, respondents mistakenly say procedural mechanisms are universally considered to require rational basis review. And second, respondents purport to know the framers' intent of 1985-3. The first point of rebuttal are procedural mechanisms are not universally considered to require a rational basis. A procedural mechanism that is discriminatory in purpose, even if on its face is neutral, is subject to heightened scrutiny. And this scrutiny for this law
And when you say discriminatory, discriminatory as to a group or discriminatory as to the opposing political party?
discriminatory in its intent. In this particular law, Your
Intent
Honor,
toward whom, though?
the
Who's the
intent,
victim, I guess?
the victim is those who support the Hope Political Party's ballot initiative and the Hope Political Party. The timing in this case makes it very suspect that there was discriminatory intent in the Congress's purpose of passing this law. And the effect of this law is a disparate impact on the Hope Political Party.
You heard your opponent say that perhaps Hope isn't a political party, but rather a movement, much like the Tea Party or the Wall Street movements recently. What's your response to that?
Your Honor, as page 3 of the complaint will note, the Hope Political Party is a registered political party. They are not simply a movement that is so uncentered as the Tea Party movement or the Occupy Wall Street movement. The second point the respondents make is the purport to know the framers' intent of 1985-3. However, the framers saw it necessary to include language in the statute of 1985-3 that condemned conspiracies against supporting a qualified political candidate. When the language of statute is unambiguous and the statute is lawful, it is the court's role to uphold this statute. In conclusion, as stated in Ashcroft v. Iqbal, whether a complaint states a plausible claim for relief will be a context-specific task. I see my time is up. May I have a moment to conclude?
Yes.
Thank you. Is a context-specific task that requires a reviewing court to draw on its own judicial experience and common sense. The petitioners have stated claims upon which relief can be granted, and for these reasons, we respectfully ask this court to overturn the holdings of the lower court. Thank you.
Thank you. Thank you to all 4 of you for your excellent arguments, and we will take a brief adjournment and be back in a few minutes. So thank you very much.
All rise. This court is now in recess.